Welcome to the Yeoman podcast. I'm your host, Geoff Graham. Today is Thursday, February 28th, 2024. I'm joined by Ilya Somin, professor of law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. Professor Somin joins us from Arlington, Virginia, and I'm in my home in Atlanta, Georgia. We are here today to discuss one of his very recent works, an important paper written together with his colleague Joshua Braver of the University of Wisconsin Law School. The title of the paper is The Constitutional Case Against Exclusionary Zoning. This is the professor's first time on the Yeoman podcast. Professor Somin, welcome, and thank you for joining me.
Thank you so much for having me.
Absolutely. So you open the paper with the following. We argue that exclusionary zoning, the imposition of restrictions on the amount and types of housing that property owners are allowed to build, is unconstitutional because it violates the Takings Clause of the Fifth Amendment. It has now been 98 years since the Supreme Court's Euclid, Ohio versus Ambler Realty decision, which effectively created zoning. And the United States has operated with zoning as the law of the land for a long, long time. So, Professor, why make this argument now?
For a couple reasons. I want to correct you slightly. Zoning did exist before Euclid, and even after Euclid, zoning is not required to exist. Euclid just said that under the Due Process Clause of the 14th Amendment, zoning is permitted. Why make this argument now? I think there's both legal reasons and practical real-world reasons. The practical real-world reason is that zoning is a huge, enormous problem in our society because by restricting the kinds of housing that can be built in many parts of the country, including some which are otherwise extremely desirable and have valuable job and educational opportunities, we keep millions of people from moving to opportunity, which is bad for them. It prevents them from having as good a life and as high an income and being as productive as they otherwise could be. It's also terrible for society in that it means that economic growth and innovation is much less than it would otherwise be, perhaps by an enormous amount. And it particularly victimizes the poor and the disadvantaged, who for obvious reasons are more likely to be priced out of these housing markets if relatively low-cost housing cannot be built because zoning rules prevent it, such as by saying, for instance, that only single-family homes can be built in a given area, and that rules out multifamily homes of the kind that are affordable to the working class and the lower middle class. The doctrinal legal reason is that if you look at the original meaning of the Takings Clause, it is very at variance with Euclid. And in fact, Euclid doesn't even directly address the text and original meaning of the Takings Clause. We also discuss in our paper how under various living constitution theories, the case for exclusionary zoning is extremely weak. And what it comes down to is that the Takings Clause says that if the government takes private property, they must pay just compensation. One of the rights that comes with private property is the right to build what you want on the property, including particularly housing. And zoning, exclusionary zoning is a severe restriction on that right. And one that, obviously is not compensated. The governments don't usually pay you when they enact zoning restrictions that prevent you from building what you want. And if the Takings Clause were used to strike down these kinds of zoning restrictions, governments would, in principle, have the option of saying, well, we'll just pay the owners and compensate them. But given the enormous scale of this, I think few governments are going to be willing to do that. So we can address the problem by revisiting Euclid and revisiting takings doctrine generally. As we discuss in the paper, we wouldn't even necessarily have to completely overrule any existing precedents. You might not even need to overrule Euclid itself, but we could have the courts develop a doctrine which is more consistent with text and original meaning and living constitution theory, and which would have these enormous beneficial effects of freeing millions of people to be able to seek out better job and educational opportunities, and also freeing large numbers of property owners from what is overall the most severe type of restriction on private property in terms of its overall impact that currently exists in the United States. So whether you're a conservative libertarian property rights advocate, or whether you're a left of center person who wants to expand opportunity for the poor and the disadvantaged, there are good reasons to revisit this area of doctrine. Or even if you simply just care about good legal principles, good legal reasoning for its own sake, the legal reasoning of Euclid is really, really bad. And the legal reasoning used to defend exclusionary zoning against takings challenges is pretty bad as well. And courts could amend it and fix it, and they can do that even without overruling existing precedents totally. Much more can be said, and I'm sure that we will discuss it.
You've touched on a lot of my questions in there, and
sure.
And actually, you've kind of touched on them in the order that I have them written here. The first is people have. A number of scholars, researchers have attempted to quantify that cost, that huge burden, and you reference some of this in the paper. They assign numbers on it related to GDP or whatever the total cost of the burden on zoning. Like, how are they? What's and it's imprecise. There's no way they can precisely do that. I think all of them admit that, but directionally, where are they going? How do you assign a cost?
So there are several different estimates and several different ways to try to estimate it. But the bottom line is that the effects are huge. Mm-hmm. There are probably at least several million people in the United States, maybe more than that, who, because of exclusionary zoning, can't move to the places where they would otherwise have better jobs opportunities, better educational opportunities for their kids. That translates into U.S. GDP being at least several percentage points lower than it currently is. And obviously, when you accumulate these effects over time, that's a lot of wealth, potential wealth that we're destroying. That's millions of people trapped in places like Appalachia or bad inner city neighborhoods or elsewhere where there are fewer job opportunities, and where also the quality of education is worse and the like, and have to put up with higher crime rates and so forth. And those people could be liberated. In addition, there's an effect that is not easy to quantify, but it likely is significant, of constraining innovation, in that for many people, in order to become put themselves in a situation where they can innovate, start new businesses, get a better education, become scientists and so forth, they have to move to a place where there's better opportunities than they have now. And granted, only a small percentage of them really will become great innovators or great entrepreneurs. But when you're talking about hundreds of thousands of people, even if only 1 in 1,000 or 1 in 10,000 of them becomes a great innovator or a great entrepreneur or whatever, that's still a significant cumulative total of great innovation. If you live in one of these areas like I do, where exclusionary zoning has kept people out, the person or the family that moves in, it may be their son or daughter will grow up to cure the cancer and that would otherwise kill you, or that they'd make some great innovation in developing some product that you will use and the like. And while the chance that any one person will do that is very low, the cumulative likelihood that some will out of millions is very high, and we are passing that up. By not allowing people to move to opportunity. The biggest negative effect is towards those people, the poor and the disadvantaged, who can't move. But all the rest of us also suffer because we have a poorer, less innovative, less dynamic society.
Well, that seems just on its face an enormous cost. And then on top of that, you have our direct infrastructure costs required to maintain separated uses, and the effect of spreading out people by design and zoning to add to the public infrastructure costs that we all bear and the maintenance of that infrastructure. That too, added to that, seems like
that one is hard to calculate, and I'm less familiar with the literature on that. Yeah. But it is true that what sometimes happens is, if you live in one of these areas, as I do, where there's significant exclusionary zoning, some of the people who work here, the plumbers, nurses, hairdressers, and so on, who can't afford to live close by to where they work. As a result of our zoning restrictions, they end up living further away, and therefore they have longer commutes, and that leads to more pollution. But it also leads to
cost of car ownership,
dead weight losses, such as this is not in our paper, but there are these surveys which ask sort of what are the most enjoyable activities that you do during the day and what are the least enjoyable. And way down at the bottom among the least enjoyable is commuting time, like
Certainly.
time spent in your car or on public transportation or whatever it is, going from place to place. Exclusionary zoning leads to longer commuting times, and that too is a cost. Albeit we have not tried to include that literature in our article.
I mean, it's impossible to come up with these numbers.
But it adds to the cost that is inflicted. And on top of that, obviously, there's just the people who can't have jobs in this area in the first place because they simply can't live anywhere close enough to those jobs. Some of the people who do have jobs, they have longer commutes, which is a loss for them, but it's in some ways a loss for society as well.
Mm-hmm. You went on to mention one of my favorite things about your paper is that this is not a paper written from one perspective. You, as someone with affinity to the kind of originalist point of view, are co-writing this with would it be the right way to say it, a living constitutionalist or someone?
Yes.
And then you also mention a third perspective, and you go into this in the paper that I had not heard of before, the emerging anti-oligarchy tradition. So, and let me read a little bit here and ask you to elaborate on this.
Sure.
It's worth noting that our project is itself an example of how this issue cuts across conventional ideological and theoretical divides. One of us is a progressive and a living constitutionalist. The other is a libertarian and generally sympathetic to constitutional originalism. We differ on many things, but agree here. So can you describe your and your co-author, Josh Braver's, kind of ideological perspectives, what those two things mean for kind of the layperson, and as well, if you will help me understand what the anti-oligarchy tradition is. You
Sure.
go in the paper.
Sure.
You make the case from each of those three perspectives.
Yes. So my co-author and I differ both on political ideology and also on sort of legal methodology, which are two distinct things, so they're sometimes correlated. Politically, I'm a libertarian, which means that I believe that government powers should be severely limited across a wide range of issues, both economic and social and others. So, I will say the war on drugs should be abolished, but also Obamacare and Medicare and Social Security should be abolished, and also immigration restrictions should be abolished, and the role of government in our lives should generally be much smaller than it currently is. On the other hand, Josh is a progressive on the left side of the political spectrum, which generally means he does favor a much larger role for government in society than I do, particularly in the areas of economic regulation, and particularly with respect to government programs that, at least in principle, are supposed to help the poor and the disadvantaged. But here we have a convergence because we have a situation where a form of government intervention restricting property rights also is massively harmful to the poor and disadvantaged. And as we discussed in the article, has a history of racism, actually, that much of the origin of exclusionary zoning arises from efforts to keep Blacks and sometimes other minorities out of majority white neighborhoods and the like. So there's a convergence here between the libertarian and the progressive political perspective. On jurisprudentially, I'm not a 100% down the line originalist and everything, but generally speaking, I think there should be a presumption that the Constitution should be interpreted in accordance with its original meaning. That is, as it was understood at the time that the particular part of the Constitution in question was enacted. There are different versions of originalism. We go through some of them in the article, but that's the basic idea. On the other hand, Josh is a living constitutionalist. And again, there are different schools of living constitutionalism, and we go through several of them in the article. But what unites living constitutionalists is the idea that the original meaning, at least in many cases, is inadequate. It can't deal with modern problems, modern change in values, or at least it can't deal with some of them. Therefore, there should be adjustments over time. The anti-oligarchy approach, which you mentioned, I think is a form of living constitutionalism. It's one of a number of schools of living constitutionalism, and it's it has historical roots, but it's most recently been developed or perhaps resurrected by two legal scholars named Joseph Fishkin and William Forbath at the University of Texas. And they argued that an underlying value of the Constitution by which it should be interpreted is to prevent oligarchy, that is the domination of the general public, particularly the poor and the disadvantaged, by a small elite, usually an elite of wealthy people. They developed the implications of that theory in various respects. If you're interested, you can read their book, The Anti-Oligarchy Constitution, which we cite in our article. But a key implication of we argue that their theory implies that exclusionary zoning should be declared unconstitutional, because what exclusionary zoning does is it keeps out the poor and the disadvantaged from places where there's more opportunity otherwise for them. And that, is an obvious problem. It exacerbates inequality. Often, though not always, it serves the interests of a smaller elite, sort of wealthy people who want to keep the poor out of their communities, things of that sort.
On top of that, in that vein, it creates a dynamic in the real estate development industry where the only people who are multifamily developers are very large corporations or who are landlords, and no longer may the small property owner be a multifamily landlord, or their opportunity to be so is meaningfully abridged.
Yeah. Here, I want to be careful because I think a lot of large developers and large corporations would, in fact, be happy to see exclusionary zoning go because of the fact that it would create profit opportunities for them. They could build new housing on a larger scale in various places. But what is true is that when you have zoning restrictions, which make it very difficult to build new housing in response to demand, the people who can build it usually tend to be the politically connected developers and the like. And so they have some interest in maintaining this. And obviously, people who own large amounts of existing housing in some cases can benefit because the value of their housing is increased, though it's complicated by the fact that in many cases, many property owners might actually benefit from ending exclusionary zoning because the value of the property as a whole would be more valuable if it could be used for multifamily housing in many cases than for single family housing. So I want to be careful about the idea of saying that, large corporations or the rich as a class tend to benefit from this thing. Overall, I think rich people end up losing because they lose from, the lower economic growth in society, lower innovation and the like. But there are certainly specific classes of wealthy interest that can benefit. And there is a history of so-called NIMBY types, not in my backyard types, who are opposed to zoning, and some of them, not all, but some of them are simply wealthier people who say, I just don't want poor people moving into my community.
When you say, I want to make sure you didn't misspeak, when you say who are opposed to zoning, you mean who are opposed to zoning reform?
Who are opposed to zoning reform.
Yeah,
I apologize.
Yeah.
They're opposed to zoning reform. There are various reasons why they might be opposed, but in some cases, it's clearly a matter of, these are affluent people who do not want poor people moving into their community. Mm-hmm. That was what was going on in the Euclid case in 1926, which you mentioned.
Clearly. Yeah, you just read all those opinions. It's very clearly that.
Yeah. If you read the district court's opinion in the Euclid case in the district court, the district judge struck down the exclusionary zoning there. It's very clear that, he openly says, the point of this is to keep poor people from moving into wealthy neighborhoods. He even says, and he was correct in this prediction, that if this is allowed, it will be used to keep Black people from moving into white neighborhoods. That, of course, is exactly what happened in many places after the Euclid decision, and in some cases also before. The Supreme Court had said in a 1917 decision called Buchanan versus Worley, that state and local governments are not allowed to have explicitly racial zoning, like a city had tried in that case, where it said, well, Black people are not allowed to move into majority white neighborhoods. But exclusionary zoning, which is on its face neutral, often has that same effect, because in an era, particularly in the early 20th century, but even today, where blacks are on average poorer than whites, if you ban multifamily housing or you ban other forms of relatively cheaper housing, that has a disproportionately negative effect on blacks compared to whites. That would also, of course, excludes the white poor as well. And in many places, these forms of zoning were pursued in part because they said, well, we can't explicitly exclude people based on race, but what we can do is we can make it impossible to build relatively cheap housing, and that will exclude most blacks, even if not quite all of them. And that was a significant motive for exclusionary zoning in many places for many decades.
Well, I would say to this day, as a real estate developer, when pursuing rezonings to enable a variety of uses within a property zoned exclusively for single family residential, people will stand up at public hearings and say things where you're kind of astonished they're saying it out loud. They're explicitly talking about the desire to keep out undesirables and the need to preserve exclusionary zoning so as to keep their city town.
Yeah. So
exclusive.
I think today, as opposed to 50 or 100 years ago, I think there's many fewer people who, in their mind, the undesirables are people of a different race, but there's certainly more who would say, well, the undesirables are people who are significantly poorer than me. That I think that concern, is there. And here, in Arlington, Virginia, where I live, we have had the debate over so-called missing middle housing. Mm-hmm. This is a community that is over 80% Democratic. It voted for, Joe Biden by over 80% in the 2020 election. And in other elections, you have similar results. And, we have, lots of people have Black Lives Matter signs in their lawn, but there also clearly is a contingent of people who say, like, we don't want poor people moving in, or at least we don't want too many of them moving in. So the Black Lives Matter, but it's better if the Black lives are not too close to me. That's sort of the attitude that not everybody, but some people, sometimes have, or at least they might say, it's fine if it's sort of relatively wealthy Black people, but if it's poor people, whether Black or white, I don't want too many of them. That would be bad for, the character of the community, or whatever you want to call it.
That is certainly, in my neighborhood here in Atlanta is probably very similar. There are a great many signs in people's yards that on the one hand call for social justice, and next to it is a sign to go out and oppose the city of Atlanta's efforts to liberalize.
It's easier to be for social justice when the people who have to pay for it is somebody else, or in this case, you're not even really paying for it directly, but you have this fear, which can be understandable, that sort of the character of the neighborhood will change, and it'll change in ways that I don't like, perhaps.
We probably over-indexed on both the utilitarian case for zoning reform or overturning exclusionary zoning, reversing exclusionary zoning, however you'd phrase that, and also the social justice, I'd say, case for doing so. We haven't much talked about the notion that the property rights reason, like, it's your land, you ought to be able to do with it what you want to do with it.
Yeah. So let's say you don't care about social justice, or maybe even you don't care about economic growth or whatever, though survey data shows many people do care a lot about economic growth. But let's say you don't. Let's say you're a libertarian or some other kind of property rights advocate just says we have a natural right to property, and that's what matters. Still, what this is if you own a piece of property in one of these areas, it severely limits what you're allowed to do with it. You cannot build multifamily housing. In some cases, even with single family housing, it has to be housing of a particular size. The lot has to be a minimum size, and so on. And just as a pure matter of like letting you do what you want on your own land, this is a very severe limitation, and it affects hundreds of thousands or even millions of property owners. Mm-hmm. In terms of its cumulative impact on American property owners, this kind of zoning restricts property rights more than any other policy that we have. It's against my interest to some degree to say this, because I spent much of my career writing about eminent domain and about things like the Kelo case and the like. And I think that is also a problem. But in our time, at least, our biggest property rights issue in American society is not the government coming in and taking your property physically for bad reasons or for reasons that are problematic, but rather the government saying, yes, in theory, you are still the owner, but we forbid you to do this vast range of things. And in practice, maybe the only thing you're allowed to do on this piece of land is have a single family house of a particular type. It's true, legally speaking, you are still the owner. The government has not formally tried to use eminent domain. The government hasn't sent anybody to physically occupy your property, but nonetheless, it is a very severe constraint on what you're allowed to do. And when you multiply that out over hundreds of thousands or even millions of property owners in many places across the country, it is a huge property rights issue, even entirely aside from the effect on people who want to move in, or the effect on the economy, or the effect on race or the like, or the history of racism that was involved here. Even if there had never been any racism, and even if the economic effects were not as large as they in fact are, still this is a very severe restriction on property rights. And if you care about property rights, then you should care about this.
It is nice, at least for me. It's totally, it totally affirms all my preconceptions and biases that by caring about property rights, I can benefit those who are disadvantaged and create more value in the world. Yeah. And that's a great thing.
There can be situations where someone's property rights really are somehow in conflict with the interests of the disadvantaged or whatnot. In this case, they are aligned. Mm-hmm. Adam Smith famously said, "It is not from the benevolence of the butcher and the baker that we expect our dinner," meaning if the butcher and the baker are allowed to produce in a free market, they will make food for you, for all of us, that because of their self-interest. Similarly, it is not from the benevolence of the developer, the builder, or the property owner that we expect to get housing. It is from the fact that if you allow people to build what they want, in many cases, they will have incentives to build multifamily housing and other kinds of lower cost housing, which can provide, housing stock for everybody, but particularly for the poor and the disadvantaged who otherwise not get it. That benefits them, but it also benefits the rest of us, because if those people are more productive, more innovative, get a better education, and so forth, that benefits the rest of us as well. I'll note one other way in which current property owners can benefit, and that is that, yes, you can make arguments about, if exclusionary zoning was abolished where I live, would the property in my house be more expensive or less expensive? Even if it's less expensive and you could say I suffer a financial loss that way, I have kids and I want them to be able someday to live in an area like mine, even if they don't make quite as much money as I do. I'm a law professor and my wife is a lawyer as well, so don't tell my dean I said this. If he asks, tell him I'm underpaid and I need a raise. But the truth of the matter is that we're pretty wealthy, which is why we can afford to live in an area like this. I want my kids to be able to afford to live in an area like this, even if they're not law professors, or even if they're not lawyers, even if they have jobs with more modest incomes, because that's what they choose to do. And anybody else who's in my situation who has kids, even if they're thinking about this just purely from their narrow self-interest, which they shouldn't do, we should care about the rest of society. But even if you're like, I only care about my family, that's what's important to me, still you might want to ask, do you want your kids to be able to live near you when they grow up? Do you want them to have a really big gargantuan mortgage that they have to pay off? Or maybe would they be happier if they had a somewhat smaller mortgage, and so forth? And I personally think most people would say, I want my kids to deal with a smaller mortgage rather than a big one. And I want my kids to be able to live near me if they so choose, and to be able to do that, even if they don't have, lucrative careers like, being a lawyer or a law professor.
Certainly, we probably don't need to go into it here, but the connection between exclusionary zoning and housing affordability is very close and very well established.
It's overwhelming. It's basic economics 101.
Yeah.
If you make it difficult or impossible to build new housing in response to demand, the price goes up. It's similar to how, if we make it difficult or impossible to build new cars when more people want to buy cars, the price of those will go up. If we restrict the amount of food that can be produced, the price of food will go up, and so on.
Sure.
And there are actual governments which have done things like this historically, including sometimes ours. Every time it leads to price increases, and that's what has happened in the housing market.
So I'm impressed that you have been able to, I got the impression you're saying you have been able to persuade people by suggesting to them that it's in their children's best interest to allow their neighborhood to allow multifamily or allow more zoning liberalization.
Know to what extent I've actually persuaded a significant number of people with that particular point or not, but I've made it in various writings. I don't have, survey data showing like which readers.
I have a version of that argument that is the only argument that I've ever used that has worked. And it has not been that, wouldn't it be great if your children could live here? It's when you are too old to live in your home, do you want to be forced to leave this neighborhood? Like, wouldn't it be nice to be able to downsize and stay in this neighborhood? Because presently it's illegal for you to be here, and you're opposing, you're being oppositional to the idea that it might someday be legal. That has seemed to have broken through.
Yeah, that is an additional and related argument, but also if you're talking about sort of the care of the elderly, if your children are able to live closer to you, they can help with that care. And you can see them more often, even at a time, if you're elderly and frail, it may be harder for you to travel. But if your children live nearby, they can visit you more often, which, as I understand it, elderly people, most of them, they like that, at least if they're on any kind of reasonably good terms.
You have children, right? How old are your children?
My kids are 8 and 5. So
okay, they're little.
Hopefully it'll be sometime before I'm so old that they need to take care of me and the like. But I hope, that, when they're adults and, I'm older, that, they will want to live in at least, some reasonable proximity to me. And I don't know yet what they're going to do for a living, but even if they're not lawyers or law professors, I would like them to have the option of living in this area if that's what they want to do. Agreed.
I want to touch on a few more topics before I let you go, one of which is Houston. And so when I criticize exclusionary zoning, which is how I spend roughly 17% of my waking hours, defenders will inevitably invoke the city of Houston's lack of zoning, the implication being that cities without zoning have the same problems as cities with zoning. So therefore, they argue zoning isn't the cause. You address this in the paper, and will you describe what Houston has had historically and how that relates to zoning?
Yeah. So two things. One is the cost of housing in Houston is way lower than in comparable cities that do have exclusionary zoning, and it has remained comparatively low, even though over the last 20 to 30 years, Houston has had a very big expansion in population. And so most land use scholars will tell you that although Houston has some problems, and we'll talk about them in a moment, then nonetheless, Houston and some other cities, which Houston is unusual in not having zoning at all, but other cities where zoning is looser, including other cities in Texas, they tend to have cheaper housing costs as a result. And this is actually one of the reasons why Texas has gained population relative to other states for the last 20 or 30 years. It's not because everybody really loves the social policies of the Republican Party that rules Texas state government. It's because cities like Houston, they can build new housing in response to demand, and therefore the price of housing remains relatively low. I actually lived in Houston for a year. Coming there from the East Coast where I'd lived before, I was really impressed with how you can get a really nice apartment pretty close to downtown Houston, and you could get it for a pretty modest sum. And on my modest salary that I had at the time as a clerk working for a federal court, I was like, yes, this is great and amazing, and it's so amazing that it totally outweighs any possible negative downsides and so forth. That said, Houston does not have a total absence of land use regulations. There are some restrictions, like For instance, they restrict what can be built next to daycare facilities and schools and the like. They also have homeowners associations, which are private voluntary groups, which all the property owners in the area can get together and they can make agreements among themselves to have certain kinds of land use restrictions. Some people say, well, that's just as bad as exclusionary zoning, but there is this difference. I think we mentioned it in the paper. I'd have to go back to see if this is in the current draft or not. But if it's not, it should perhaps be in a later draft. Anyways, my answer to this argument is that with homeowners associations, their scope is inherently limited because they have to have the 100% unanimous consent of all the property owners who are subject to their restrictions. And that makes it virtually impossible to have severe restrictions on housing construction throughout a vast city or even a medium-sized suburban town and the like. So even if you and I and 100 of our neighbors get together and say, okay, we have, the Somin Graham HOA where only single family homes are allowed, still there are going to be lots of other people in the neighborhood who, they're not going to have an arrangement like that. Multifamily housing can be built there. And that is what you see in Houston. You have some areas where HOAs may have restrictions, but not far away, often within just a mile or two or three, you see places where multifamily housing is there. And if you go around Houston, you will see a lot more interspersal of multifamily housing and single family housing than you will see in places that do have severe exclusionary zoning, like, for instance, where I live in Arlington County, which until recently, until the adoption of our missing middle reform, something like 80% of Arlington County was zoned for single family zoning or single family housing only. And that is very different from housing. And it is one reason why we have a problem with severe housing costs, whereas Houston, for the most part, does not. Although I do not mean to say by that Houston's regime is absolutely perfect in every respect. It isn't, but it's vastly better than exclusionary zoning. And if you just go to Houston, you see what's there and you check out the housing prices. If you're used to sort of East Coast, big city and nearby suburb housing prices, you will be very impressed with how much lower they are in Houston.
Well, Houston, a couple additional things about Houston, and I think you reference these in the paper. Houston historically has had kind of a sort of zoning where they've had minimum lot size requirements throughout much of their recent history, where lots had been required to be very, very large. And so much of when people tend to point at Houston and criticize it as lack of zoning not being good, I don't think they tend to be speaking about the affordability side, which is clear benefits, but the visually of the built environment part, those lot size requirements have largely gone away recently, and their housing both the quality of their built environment and the housing affordability has skyrocketed in recent decades.
Yeah, so in the minimum lot size, although it's not called that in Houston, minimum lot size requirements are also often a kind of zoning. And what they do is obviously if only bigger lots are allowed, then that makes each lot costlier and sort of poorer people can't afford them. It's less of a problem if the lot can have multifamily housing on it, because then it's not, if you're moving in there as a lower middle class person or a working class person, you don't have to buy the whole lot or rent the whole lot. You can just rent one apartment in one building, which is what I did when I lived in Houston. I certainly didn't have enough money to buy the entire lot, but I rented one actually quite nice one-bedroom apartment in a sort of multifamily home where I then was just 8 or 10 minutes drive from downtown Houston where I worked. If you try doing something like that in a big East or West Coast city which has exclusionary zoning, the cost will be way, way higher. But yes, Houston still has had historically some restrictions, not all of which I think are justified. It is not a libertarian utopia or any kind of utopia, but it is vastly better than what cities with severe exclusionary zoning do, and we can learn from them. I think their experience shows a lot of what is possible. Though I think in some ways we can do even better than they do.
Right.
But even if the whole country ends up with a system that's about as good as Houston's, that would be an enormous improvement over the status quo in very large parts of the country.
I would direct people to check out Emily Hamilton's work on zoning and land use and the reforms
she does great work.
Houston.
And she makes these points. Also, Edward Glaser at Harvard University, who is perhaps the world's leading land use and housing economist, he has written about Houston, and he talks about how Houston, has, because of their relatively minimal restrictions on the construction of housing, they have managed to keep housing prices relatively low despite enormous increases in population over the last several decades.
I'll link to both of those in the show notes.
Yes.
I have a question for you about the connection between zoning and other forms of restrictions. So when does something become a taking? And y'all argue that zoning is a taking, Houston's restrictions are de facto takings. You present how those arguments would look, and they should therefore be unconstitutional for similar reasons. Do your arguments extend to requirements imposed by building code, permitting inspections, so forth? And we'll just answer that question.
Yeah, it's a good question. So we can consider a number of different theories, originalist and living constitutionalist, in our article. And all of those theories, we argue, would have the implication that exclusionary zoning is a taking. That is, exclusionary zoning that restricts the nature and type of housing that you can buy, with only rare exceptions. That would always be a taking. I think the different theories do have potentially different implications for other kinds of land use restrictions. In particular, the originalist theory, that does have an implication that a good many other restrictions on the use of property, like restrictions on many commercial uses, would also be takings. Under the originalist theory, there would still be a limitation under the so-called police power exception, where there are some land uses that under the police power could be restricted in ways that would not be a taking, because those uses pose some kind of serious threat to health or public safety and the like, for example, if the use would create flooding, or if you want to use your house to breed rats or something, and diseased rats would spread from there. I think that could be restricted, and there could be other things like that as well.
Would that be I've always felt like, if you want to breed rats, that'd be fine to breed diseased rats, but the problem would come from you allowing your diseased rats to begin contaminating your neighboring property.
Yeah, I think the issue there would be that that the likelihood of rats spreading from any rat breeding operation is so high, given how easily rats spread, that the police power could be used to restrict that.
Yeah, I guess that's an extreme example.
I agree, and I think, properly understood, the police power allows banning only fairly or severely restricting only fairly extreme land uses, like those that create disease, rats, toxic waste, pose a threat of flooding or landslides, things of that sort. But you could potentially have a somewhat broader police power exception than that, and still not get to the point where it's broad enough to allow forbidding multifamily housing and the like. Under the living constitution theories, by contrast, there might be a pretty wide range of other land use restrictions which would not be considered takings, because under the various living constitution theories, it's important and crucial that exclusionary zoning has the effect of preventing large numbers of people from moving to opportunity, particularly the poor and the disadvantaged. The racial history of exclusionary zoning is also important under some of the theories, whereas there might be other land use restrictions that don't have a similar awful history. And so many restrictions on commercial and industrial uses would not be affected by these living constitutionalist arguments. But when it comes to housing construction, I think almost all restrictions in housing construction and use for housing would be considered takings, except in rare instances where building this kind of house would pose a health risk or the like, such as
that would be like the International Building Code, which specifies the manner in which a house may be built.
Yeah. So rules about things like, there must be a fire escape or something like that, or, restrictions on very flammable substances or something, those I think would fall in a different category. I would add also that even if you say that those are still takings, realistically, the amount of compensation that people could get from those would be pretty modest, because in many cases, adding a fire escape is not that expensive, or adding or like not using super flammable material.
There is a bit of a death by 1,000 cuts type thing on there where
but once you get to the point where it's 1,000 cuts, I would bet many of the cuts, the marginal addition in terms of safety that they create would be so low that maybe it wouldn't fall within the police power exception. In any event, I don't deny that for our theory, as for a wide variety of legal theories, a creative lawyer or a creative real estate expert like you can come up with, sort of borderline cases which may be hard to adjudicate. This is an inevitable consequence of any legal rule where you don't have an absolute bright line, like that you have to be 16 years old to get a driver's license or something like that. But even though there might be some difficult borderline cases, there is a vast range of easy cases. And it is those easy cases that are causing our housing prices, our housing crisis. It's not restrictions about, fire escapes or not using highly flammable materials. It's, rules which say you can only build single family housing over this vast area. And that, to my mind, is an easy case, even though you and I can easily come up with sort of some more difficult borderline cases.
Yeah, there is. I'll link to it too. There's a lot of discussion now related to the number of staircases multifamily and elevators multifamily buildings are obligated to have, that dramatically increase the cost of construction. And that's a related topic. But we have so many things that I want to be able to ask you before I let you go that I can't go down that rabbit hole. And you alluded, you touched on these several questions in your response just then. But in your paper's scope, you narrow your paper's scope to housing, and you do not talk about zoning in terms of you don't address zoning as it relates to specifying type of use, so commercial, retail, industrial, so forth. Yeah. What is there a reason why you kept your scope that narrow?
For a couple reasons. One is just as a practical matter, for one article, even addressing housing, is a big issue. Second, as I mentioned before, some of the living constitution theories would have different implications for limitations of industrial uses and commercial uses as opposed to housing. And we wanted to highlight this area where a bunch of different theories converge. That
makes sense.
But we recognize that there are going to be other areas where they don't converge.
And in terms of the type of what would be a couple of people asked this question on Twitter when they saw that you were going to be joining me. Who would be the ideal plaintiff for this?
So that's a good question. And I think it may be that the ideal plaintiff would differ somewhat between different states and localities and the like, but I would say thinking about the ideal plaintiff for a public interest case, which is a case that's brought to set a general precedent as opposed to just win something for the property owner or for the litigant. One is it would have to be somebody that's willing to be in it for the long haul, that that it might take several years to litigate a precedent-setting case up to a state Supreme Court or to the federal Supreme Court or whatnot. Second, from a there is a for doctrinal reasons, it should be clear that this is a kind of housing construction where it's very hard to argue that it poses some kind of health risk or some kind of safety risk or the like. Third, from a public relations point of view, it should be the construction of housing that is likely to be affordable for lower middle class or working class people. From a strictly legal point of view, I don't think that's necessary. It's especially not necessary under originalist theory, but when you litigate public interest cases, other things equal, you want an appealing client, even when a client with an appealing situation, and one that sort of dramatically highlights the broader problem. And obviously, you would want a client that, it can't be argued this is some kind of shady person with say a landlord with a history of stiffing their tenants or something like that. Again, legally speaking, it shouldn't matter. Bad people also have constitutional rights. But from a public relations point of view, we want somebody who is clean, appealing, doesn't have skeletons in their closet, and so forth. It may, in a certain sense, be unfair, because again, people with shady past or whatnot, people who are sketchy or whatever, they have constitutional rights just like you and I do. But from a public interest law point of view of sort of the ideal client, it would be somebody who has, and the ideal case would be where you have a client in a situation that fits the parameters that I mentioned. You would also perhaps want an area where the zoning restrictions are very severe, like only single family housing is permitted, and only if the lot is really big. Or something like that.
Is it, I guess, related to that? Can you speculate on what organizations would be supporting that plaintiff in this journey?
So I don't yet know for sure, but I would note two kinds of organizations. One might be something like the Pacific Legal Foundation, which litigates a lot of takings and property rights cases. Full disclosure, my wife is an employee of the Pacific Legal Foundation, but she does not do property rights cases. She does other kinds of cases. But I note that, you can, if you want to say that's a conflict of interest, you can say that, but I disclose it. And for the record, I myself have been involved in property rights causes for many years, since long before I met my wife, much less than she started.
Is that how did you meet through the overlap of those things?
I'm sorry?
Did you meet professionally?
Not exactly. We met at a party sponsored by an academic organization that we both won fellowships from. And it was only 11 years after that, or 12 years after that in 2020 that she, took the job at POF, and she previously worked for the federal government. Another possible organization might be the Institute for Justice, which litigated the Kelo case and other kinds of takings cases. On a different side of the political spectrum, both of these are sort of libertarian organizations. I can imagine sort of liberal, affordable housing or housing rights advocates bringing cases like this as well.
When an organization helps a plaintiff bring a case like that, what do you refer to them as? Is there a term?
So the usual term is a public interest organization, and the way it works at POF, Institute for Justice, and also groups like the ACLU, is that they will find a plaintiff who is interested in bringing the case, and they will represent that person for free. But the person also understands that they will try to litigate the case to the point of where it will actually set a precedent, and that other things equal, they might have want to avoid a situation where they settle out of court, for example, though public interest organizations will sometimes still accept out of court settlements. But unlike the conventional lawyer, where the conventional lawyer's goal usually is to win the case for your client by any means necessary, ideally, a public interest organization wants to get the case to a point where it'll set a broadly more applicable precedent. And there's a long history of public interest organizations doing that. Many of the most famous decisions in American history were brought in this way. Brown versus Board of Education was brought by the NAACP for the purpose of setting a broader precedent. Their goal was not primarily so that Linda Brown as an individual could attend an integrated school. And in fact, she never did. By the time Topeka, Kansas schools were fully integrated, she had graduated. But their goal was always to set a broader precedent. And that's why they represented her on a pro bono basis.
I would imagine it would be a long list of organizations that would want to support.
I don't know if
it's
a long list, but it's a somewhat considerable list. Obviously,
Institute for Justice and
the Institute for Justice and the Pacific Legal Foundation are the two principal public interest groups that do property rights cases in the United States.
And for those interested, those are great organizations.
And I have worked with both of them over the years. I was a summer clerk actually for the Institute for Justice when I was a law student, and that is one of the things that got me interested in takings questions. And I recommend it to any law students who may be listening. Both POF and Institute for Justice, have programs for law students that can work during the summer, sometimes even during the academic year as well. It's a great experience, whether or not you end up in a career doing this sort of thing.
If you could, let's see. Let me give a quote from the paper, and I'll ask you to explain it to me, because as a layperson, I was a bit lost in it. A less aggressive approach, and I've mashed a couple things together for brevity. A less aggressive approach, which would keep exclusionary zoning under the Penn Central framework, but make that framework far less deferential. That's a phrase in there. As a layman, that was getting a bit beyond me. Like, can you explain the notion of deference and how it applies here?
You've picked something that is not easy to explain, even sometimes to other
Maybe
lawyers.
That should be the second
But let
episode.
me try, and you can tell me whether it's clear or not.
Yeah.
So under current Supreme Court precedent, there are certain kinds of government actions and regulations which are what are called per se takings, which in plain English means that if the government does this, it's automatically a taking. An example would be if the government just comes and occupies your land. Like if they if they put a giant dumpster on your land and say you have to have that on your land, that's a taking automatically. Similarly, if they let people physically occupy your land, that's automatically a taking. And in the Cedar Point case in 2021, the Supreme Court said it's automatically a taking if they authorize people to come onto your property, even if it's just temporarily. On the other hand, most regulations which don't involve a physical seizure of property or an occupation, they are not per se takings. They fall under a three-factor balancing test, which is called the Penn Central test, after this 1978 Supreme Court case, which involved the Penn Central station in New York City. And there, if the government just adopts a regulation which restricts what you can do with your property, and that regulation does not destroy all of the economic value of the property, but only destroys some of it, then they apply a three-factor balancing test. One factor is the character of the government action. Another factor is the extent of the economic burden that the government regulation inflicts on you. And a third is the extent to which it involves restricting in reasonable investment-backed expectations that you have. Now, the application of this test is extremely murky and fuzzy. Like the test doesn't tell us what happens if two factors cut in favor of the property owner and one cuts in favor of the governor, vice versa. It's also kind of nebulous what the character of the government action is and what kinds of actions have a bad character, if you want to call it that, and what kinds have a good character. It is similarly nebulous how big a negative economic impact there has to be before it's big enough that it helps the property owner as opposed to government. So what typically happens, and I'm oversimplifying what typically happens, is that if a court rules that this is not a per se automatic taking, but rather that it falls within the Penn Central three-factor test, usually courts tend to be deferential to the government, and most of the time the government just simply wins. And what we propose as a best option is to simply say that exclusionary zoning is a per se taking. That is, at least most forms of it are automatic takings, and therefore we wouldn't have to deal with the three-factor test and all of its uncertainties and problems and mind-numbing complexities and so forth. But if you don't like that approach, or if a court doesn't like that approach, you can maintain the Penn Central three-factor test, which is currently the test applied to most kinds of zoning, but you can make that test less deferential. For example, you could say that an exclusionary zoning restriction, or at least a severe one, that means the character of the government action automatically counts in favor of the property owner, or at least counts in favor of them a lot. Similarly, under the economic impact aspect, you can say that there is a strong presumption that weighs in favor of the property owner as well. So you can, in effect, sort of rejigger the Penn Central test as applied to these kinds of situations to make it less deferential and to make it easier for property owners to win these cases, but you then would not, junk the Penn Central test entirely, and you wouldn't even junk it with respect to exclusionary zoning cases. You would just make it less deferential. Now, if this seems to you like sort of the kind of hackery that makes people not like lawyers, I can understand that. But this is the nature of the Penn Central test that the Supreme Court has created. If it were up to me, I would go really far and just get rid of the Penn Central test for most things and make a lot more things per se takings. But if you don't want to be as radical as that, you don't want to, you don't want to more severely restrict or completely overrule this longstanding precedent, then you have this sort of more moderate path of working within the three-factor test, but making it less deferential, at least in cases involving exclusionary zoning.
It would seem to me like arguing under that three-factor test. That's what the Penn Central framework is, right? Like that would be tedium upon tedium.
So it can be tedious and sort of, on the one hand, this increases employment opportunities for takings lawyers like me, because this three-factor test, as I think you can readily see, even a layperson can see, this is not a very precise test. It's you can argue different ways about different things on it, and this is the kind of thing is why lawyers can make money, right? That things that are hard to rules that are hard to interpret, and that it's hard to figure out what's going on there. So again, I would prefer a clear system where many more things are just considered per se takings, and I would prefer here, as we state in our article, that the courts just declare that exclusionary zoning, with rare exceptions perhaps, is just a per se taking. And then you wouldn't have to deal with those three factors and what they mean and how they balance against each other or any of that, mumbo jumbo. But if you want to maintain the precedent and you want to keep applying it to zoning, then you can make incremental adjustments.
Which this court seems like they're not so particularly attached to precedent they deem as bad precedent.
My read of the current Supreme Court is that they probably don't want to get rid of Penn Central entirely, or at least there's not 5 votes for it. On the other hand, they have been willing to make more types of regulations per se takings, as they did in the Cedar Point case that I mentioned earlier, where they said previously the dominant understanding of precedent was that a physical occupation is a per se taking, but only if it's permanent. But here they said even a temporary physical occupation is a per se taking, thereby saying there is a per se taking with respect to a California law, which said that union organizers can go on the property of agricultural growers up to 120 days per year, 3 hours per day. So it's not permanent in the sense that they can go there anytime they want. I had argued in a piece that I wrote about before this case came down that maybe you could say that it's permanent in the sense of being indefinitely recurring. Like you can do this up to 120 days per year, every year on into the indefinite future. And to my mind, that is a kind of permanence. But the court didn't care about that aspect. They just simply said, even if it truly is completely temporary, a temporary physical occupation is a per se taking. So that means that if they say I can step on your land and spend an hour there just one time, that's a per se taking. You probably won't get a small amount of compensation, but you will win your case if you file your against that law. And if that's a per se taking, I say if they tell you can only build single family housing on your property and nothing else, that strikes me as it should be a per se taking as well.
So related to that, or this is a nice segue into my penultimate question, and I hope we'll have time for the last two. So if zoning is now, in most places where it is, it's multi-generational now. So like if you have acquired a property, whether you purchased it or inherited it or whatever, it was probably already encumbered with exclusionary zoning. It was not imposed upon you prior to your getting it.
Yeah.
In that scenario, what was taken from whom and how?
So my answer to that is the Supreme Court resolved this issue in the Palazzolo case in 2000, where they ruled that a regulation which pre-existed your acquisition of the property can still be a taking. And the answer is that even if the regulation existed before you bought the property, still it's a regulation that restricts the property rights of the owner, whoever that might be. When you bought the property, you bought all the rights associated with associated with ownership, setting aside cases where there can be divided ownership. Like sometimes, I might own one right with respect to a property and you might own another, but whoever has the right to build on the property, that person's property rights are restricted, and it does not matter whether the restriction was created by the government before you bought it or afterwards. This is something we're going to add to the paper because while it's well known to takings experts, it's not well known to other people, including even other lawyers or other legal scholars. So we're going to, before
that was new to me, and I know way too much about this topic.
Before our article gets published, we're going to add a brief section citing to Palazzolo where we explain this point.
Gotcha. And I have a final question for you. And thank you very much for spending time today. If 1926 had never happened, or I should say you clarified, and if zoning didn't exist today, and if Euclid or something like it came before the Supreme Court today, can you speculate on how they would decide that?
Obviously don't know for sure, because if we lived in a world where there had not been exclusionary zoning for the last 100 years, it would be a very different world in various respects. I think overall it would be a better world. There would be more property rights, many more people would be able to move to opportunity and so forth. But I do think that under an originalist methodology, at the very least, there's a very strong argument that if such a thing were attempted to be instituted now, that it should be ruled unconstitutional. If you imagine that the court, had ruled differently in Euclid, then there would still be later history to have to think about, would that have been overruled during the New Deal era, which followed a few years later and weakened a lot of judicial protection for economic and property rights of various kinds. So, I like analyzing counterfactual history, but to deal with that counterfactual, we might have to take much more time than we currently have, because it would be a very big counterfactual. And you would have to ask, what is it that led if the court had maintained that these kinds of restrictions are not allowed, then what else about the court and society would be different? And if the counterfactual is that no zoning had occurred, zoning has simply not occurred or not occurred in a large scale, then there's also issues. Well, what is it that caused it to not occur? And, would it have impacts on, the rest of society? But you can imagine a society where commitment to property rights was maintained more than it was in the 20th century. Or you can imagine a society where, there was less racism and classism, if you will, than there was in actual
institutionalized.
Yeah. And I think both the society with stronger property rights or the society with less racism and classism, or preferably the society that had both A and B, that would have been better than, what actually happened, I think.
Agreed. My guest today has been Professor Ilya Somin. He's the co-author of the new paper, The Constitutional Case Against Exclusionary Zoning. Everyone should go out and read it. You can access it online for free. Professor Somin, thank you so much for joining us on the Yeoman podcast.
Yeah, thank you. I should note perhaps that our paper has been accepted for publication by a number of journals. We should have an announcement within the next few days about which journal is the one to actually also.
Excellent. Well, it may be that news is out before this is published. And so when this podcast is published, so I'll reference that if that's the case. Yeah. Thank you so much, Professor.
Thank you.